So friends, in his D.C. prosecution of Donald Trump, Special Counsel Jack Smith hasn't just taken off the gloves. Looks like he's boxed them up, taped up the box, and sent them to long-term storage. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, Special Counsel Jack Smith just filed a new pleading, a new motion in Donald Trump's D.C. prosecution. You know, that's the one for Trump trying to criminally overturn the results of the 2020 presidential election. Smith and his prosecutors just filed a new motion regarding jury selection. Specifically, they're asking the court, the presiding judge, Judge Tanya Chutkan, to use a jury questionnaire. Now, this is an entirely ordinary request. I've used jury questionnaires in multiple cases. Typically, we use them in the bigger cases, the more involved cases, cases that are expected to last several weeks or several months. A juror questionnaire can help streamline and make more efficient the jury selection process. But Jack Smith and his prosecutors are concerned about much more than just streamlining the jury selection process. This new motion that they just filed is titled Government's Opposed Motion. Opposed means that Trump and his lawyers are objecting to this request because, of course they are. Government's opposed motion for fair and protective jury procedures. Now, let's go through a few passages of this new prosecution filing, and we'll stop along the way and talk a little bit about what we're seeing in this new motion. Here's how it begins. Trial in this matter, in which the defendant, a former president, is charged with attempting to overturn the presidential election, disenfranchise millions of Americans, and obstruct the peaceful transfer of power, is a matter of national importance and will likely generate significant public attention. To ensure that voir dire, that's our fancy term for jury selection, to ensure that voir dire in this case proceeds in an orderly, efficient, and fair manner, the government, the prosecutors, proposed that the court use a written juror questionnaire shortly in advance of in-person jury selection. A questionnaire would save time by allowing the court to excuse some potential jurors without requiring them to appear in court, and by permitting the court and the parties, the defense attorneys and the prosecutors, to organize and streamline their questions for in-person voir dire. Because the questionnaire process will give the parties early access to prospective jurors identifying information and the ability to conduct open source research regarding them, the jurors, the court should impose reasonable boundaries for such research and reiterate its practice, standard among courts in this district, of prohibiting public identification of potential or selected jurors. Through counsel, the defendant, Trump, opposes this motion. So friends, what we see in the opening paragraph here indicates that the prosecutors are concerned about a few things. Certainly, they're urging the court to streamline and make more efficient the jury selection process, but they're also keenly concerned with protecting the identities of the jurors and putting some guardrails, some limitations, some restrictions on what they refer to as open source research. That is, scouring the internet for information about these potential jurors. Put a pin in that one. The motion continues. In this case, the court, the judge, should exercise its discretion to streamline jury selection through the use of a juror questionnaire. At the same time, in light of the public attention that is expected and the defendant's, Trump's, record of using public social media platforms in an intimidating manner, further evinced by events in a separate trial in New York last week, the court should implement several of the standard measures frequently used in this district to protect the jury and impose additional clear guidelines for the use of information regarding potential jurors. So friends, right there on page 2 of the motion, Jack Smith signals to Judge Chutkan, oh, you bet we're going to talk about what Donald Trump did in his civil case that's underway up in New York, where he endangered the judge's law clerk. We're going to get to that, Judge. Let's jump forward to page 5 of this court filing. The court should impose reasonable and standard restrictions to protect jurors. If the court approves the use of a questionnaire, the parties will learn the identities of potential jurors in advance of in-person jury selection. It is commonplace in this district for parties, once they are provided with jurors' identifying information, to conduct open-source social media research on the veneer meaning all of the jurors who are called for potential jury service in this case. Given the particular sensitivities of this case, stemming both from heightened public interest and the defendant's record of using social media to attack others, the court should impose certain limited restrictions on the ability of the parties to conduct research on potential jurors during jury selection and trial, and to use juror research. In addition, the court should strictly enforce the standard practices in this district designed to shield juror identities from the public. And then the court filing goes through several pages of proposed restrictions, limitations, guardrails designed to protect the identity of the jurors, and also designed to limit both the defense attorneys and the prosecution in just how invasive they can get when it comes to scouring the internet, scouring social media sites for information about the jurors. Some of the proposed restrictions, for example, include you can look at anything that is publicly available about the juror, anything the juror posts on publicly available sites or pages, but you can't friend the juror trying to draw more information out of the juror. You can't communicate or attempt to communicate at all, not yourself, not through an intermediary. So look, Donald, you can't have any of your dirty associates, you know, Rudy Giuliani or Roger Stone or Mike Flynn or Steve Bannon, you know, put a friend request in for the potential jurors. That would violate the restrictions, the limitations that the prosecution is seeking to have the court impose. So no, you can't friend them. You can't communicate with them directly or indirectly or attempt to, but you can certainly view anything that is publicly available. And after the motion talks about a number of proposed restrictions, Jack Smith and his prosecutors make it abundantly clear why they are seeking some of these restrictions to protect jurors and their identities. We're going to jump forward to page 9. There are other good reasons in this case for the court to impose these restrictions and enforce this district's standard prohibition against publicizing jurors' identities. Chief among them is the defendant's, Trump's, continued use of social media as a weapon of intimidation in court proceedings. In addition to the record before the court from the government's previous filings, just last week, the defendant escalated his conduct and publicly attacked the trial judge's law clerk in his pending civil fraud trial in New York State Supreme Court. The defendant did so by reposting on his Truth Social account, which has 6.4 million followers, a photograph of the law clerk and the United States Senator with the baseless caption, Senator's girlfriend, meaning the judge's law clerk was Senator Chuck Schumer's girlfriend, because that's who the picture included, Senator Schumer and Judge Engoron's law clerk. The senator's girlfriend is running this case against me. How disgraceful. This case should be dismissed immediately. As a result, the judge in that case was forced to issue an oral order that no party speak publicly about members of the court staff. Given that the defendant, after apparently reviewing opposition research on court staff, chose to use social media to publicly attack a court staffer, there is cause for concern about what he may do with social media research on potential jurors in this case. It is therefore necessary for the court to employ the limited restrictions described above. And then, friends, before wrapping up this new court filing, the prosecutors, for good measure, quoted the words of another federal court judge, the one who presided over the case that E. Jean Carroll brought against Donald Trump. Here's what that judge had to say about Donald Trump's reckless and dangerous speech and posts and rhetoric. Defendant Donald Trump repeatedly attacked courts, judges, various law enforcement officials, and other public officials, and even individual jurors in other matters. If jurors' identities were disclosed, there would be a strong likelihood of unwanted media attention to the jurors, influence attempts, and/or of harassment or worse of jurors by supporters of Mr. Trump. So wrapping up, friends, this new prosecution court filing is designed to accomplish a few things, right? Urging Judge Chutkan to use a jury questionnaire to streamline and make more efficient the jury selection process. It's also designed to put some guardrails, some restrictions around Trump and his lawyers to make sure they don't endanger jurors, try to communicate with jurors, publicly identify jurors. But it also looks like the prosecutors are priming the well, because they put a whole lot of information in there, appropriately so, about Donald Trump's most recent reckless, dangerous speech and posts endangering a judge's law clerk. That is clearly designed to send a signal in advance of the October 16th gag order hearing that will be handled by Judge Chutkan in the D.C. case. I will be in attendance. I'll be in court, and I will sort of report out what I'm seeing and how the hearing goes. And as you've probably heard me say before, I don't often bet on the outcome of trials. It's a fool's errand. Plus, I'm not a betting man, not a high roller. $1 is my betting limit. Well, I would put the full buck on Judge Chutkan imposing some narrowly tailored restrictions on Donald Trump's speech, on his posts, on his dangerous rhetoric, sometimes deadly rhetoric, after that hearing is conducted on Monday, October 16th. Because if Donald Trump has shown anything to be true, is that he is willing to endanger witnesses, jurors, prosecutors, judges, their respective family members, and he's willing to urge his supporters to do all sorts of, let's call them inappropriate things, to try to help him avoid and evade responsibility for his crime. So, yeah, I have a very strong sense Judge Chutkan will impose what we often refer to as a gag order to try to protect others against Donald Trump. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.